All right, we had some technical difficulties. I'm back now. Guys, if I'm live, type in you're live. I can see you and freedom now. Type in freedom now if you can see me. For some reason, we had technical difficulties. As you're coming on board, say hello. I'm Latoya McBean Pompey, an immigration attorney in New York, working with clients nationwide at McBean Law. Come on in and type in freedom now. I'm told that I'm live and it's all good. Now I could see some of you. Great. Thank you so much for always being here. We're located in White Plains, New York, but we work with folks everywhere, all right, nationwide at services that we provide to clients and also global services as well for individuals in many different countries. So it's an honor to be able to do this work at such an important time. If you need immigration legal help, certainly reach out to us at 914-898-9488 or email us at info@mcbeanlaw.com. Now I'm seeing everyone is here. Terrific. We had technical issues earlier. Freedom now, guys. Freedom now. Good to see you guys. Thank you so much for being here today. Awesome. Hey there, Natasia. Good to see you. I'm live now. Perfect. Perfect. So friends, I do have some break-in immigration news to share with you, and then we're going to dive into your Q&As. I'm not in a hurry today, and then I have some great trending videos to share with you as well, in addition to some of your good news stories. If you have good news to share, please type it in now. We need the encouragement. The community needs the encouragement. Share your stories, guys, because people are very discouraged these days. So if you've been approved for a work permit, a green card, citizenship, naturalization, or a visa, whatever it is, just share that story. Also, if it's a relative or a coworker or a friend who has a good news story, share it as well so that we could encourage each other. So now I'm going to just go right into the break-in immigration news summaries at this time. All right, let's get the news in front of me, guys. There is so much happening with immigration, and I know that it can be very challenging to keep up with them all. Each week, we try to summarize the biggest stories that I think you should be aware of. And the first one today has to do with the fact that due process is back before the U.S. Supreme Court, and the constitutional rights that individuals have to be free from just being stopped and harassed and questioned by ICE without reasonable suspicion. The Trump administration has asked the Supreme Court to allow it to conduct these roving immigration raids in Los Angeles. As I've reported out to you guys, the Ninth Circuit Court of Appeals on the West Coast has actually stood on the side of the Constitution and said that that ICE agents cannot conduct raids without there being some sort of reasonable suspicion. They cannot use race or any other criteria that makes it really clear that they're racially profiling individuals when they stop them and arrest them. And the Trump administration has asked it through an emergency order, ask the Supreme Court to intervene so that they can continue to conduct those types of stops in California. The Trump administration is engaged in a legal fight to overturn a temporary restraining order that was issued by a federal judge in California, which restricts immigration enforcement tactics in the Central District of California. The judge's order prohibits federal agents from using factors like race, ethnicity, language spoken, presence at day laborer sites, or any type of work as the sole basis for detaining and questioning individuals. The Trump administration is making an argument to the Supreme Court that the judge's order is pretty much a straitjacket, right, for law enforcement, and that they need to conduct these roving immigration raids. The administration's lawyers have been questioned by the Ninth Circuit about a potential White House ordered quota to arrest 3,000 immigrants per day, a figure that the White House advisor Stephen Miller had previously suggested. And the Justice Department lawyers are now saying, oh, no such quota exists. They're back tracking on this whole notion that they need to hit 3,000 arrests per day, which is well documented. We've talked about that in the past. The administration is facing a series of legal setbacks on its immigration policies, as we've discussed last week. A judge in California blocked the cancellation of TPS for 63,000 immigrants. And then a judge in Washington blocked expedited deportation procedures for immigrants who had been previously paroled into the country. And then another judge in Washington blocked a severe crackdown on asylum applications. And so, guys, of course, we know that there will always be a fight by the administration to take things as far as they could possibly go. And our Constitution, our laws require reasonable suspicion before a law enforcement official can stop and question an individual about whatever the issue is. And so let's continue to watch what the Supreme Court does in this particular case. The second news has to do with ICE and their recruitment efforts. Guys, you might have already heard that they've eased the age restrictions. Okay, folks as young as 18 can now join ICE. Historically, ICE faced significant challenges in hiring and retaining agents, which complicates, obviously, the goal of deporting 1 million people annually. The agency has struggled with high retirement rates and low retention. And to address the staff and shortages that the department has, they're now including all of these new measures to recruit or to attract folks. And these efforts include lifting age restrictions. The minimum age requirement of 21 has been eliminated. The previous maximum age limits for criminal investigators, which was 37, and deportation officers, which was 40, have also been lifted, with limited exceptions. And then there are financial incentives, and you guys have seen those posters, right, of up to $50,000 sign-in bonus, $50,000 sign-in bonus, including student loan repayment assistance and some other benefits. The biggest issue that one of the biggest issues that I see with respect to how ICE is conducting their recruitment efforts is the potential impact that this will have on local communities, right? Because if you're working as a police officer in, let's say, Wichita, Kansas, or maybe Brooklyn, New York, and you're earning a certain salary, and then you look to the feds and what they're offering, and you see how very easy it is to get in now. They've lifted so many restrictions, and here they're offering an up to $50,000 sign-in bonus over the course of 3 years. Why would you stay in your post? Why would you stay there? Why not just go off to the feds? And so the potential impact on locals is something that I think we all need to pay attention to as well. Then FEMA, the Federal Emergency Management Agency, is temporarily detailing some employees to ICE for 90 days to help with the hiring and screening process. So here you have FEMA, okay, FEMA employees being redirected here. As far as local law enforcement cooperation is concerned, the administration is seeking assistance from local law enforcement agencies through cooperation agreements. States like Florida and Texas have already volunteered to help with immigration enforcement efforts. And then you guys know through the One Big Beautiful Bill that 170 billion in additional funding has been allocated for border and immigration enforcement, and a good chunk of the funds or our taxpayer dollars will go towards the expansion of the recruitment efforts there. So that's what's going on now. And ICE has, there's an initial response to this new recruitment effort. In the week since the new recruitment campaign has been launched, more than 80,000 Americans have applied to join ICE. More than 80,000 have applied to join ICE. So, whoa, right? Whoa. Now let's shift over to State Department. The State Department is doing a host of things over there. A lot of things are happening over at the State Department, one of which I've addressed in a very short video to you guys last week. It's on Instagram and Facebook and TikTok, I believe. And in that video, I spoke with you guys about the fact that the State Department may require visa applicants to post bond of up to $15,000 to enter the United States as a visitor. And they're starting with two countries, the poorest country in Africa, Malawi, and then Zambia. Two sub-Saharan African countries are are involved in this pilot program in which individuals who are seeking the B1 and B2 visas will be required to post a bond. Some folks might have to post a bond of 5,000, others 10,000, and then 15,000. And the bond will be returned to the visitor once they leave the United States on time. There's some additional things I want you to understand about this bond, the way it's going to work. I went into those details in my short reel, so go watch that reel. But this is starting this month, okay? It's starting this month. I think August. That date is not in my talking points here. I think it's sometime this month it's starting. I've mentioned the date in my short video and how it's going to work and all of that. So go watch that video. And then lastly, guys, on the news front, you might have also heard that the Trump administration is seeking to change how Census collects data. And they want to exclude immigrants, okay, in the U.S. illegally. They do not want those individuals to be counted. President Trump has directed the Commerce Department to change how the Census Bureau collects data, specifically to exclude immigrants who are in the country illegally. In a social media post, Trump indicated that the changes would be based on modern day facts and figures and information gained from the presidential election of 2024, suggesting a political motivation for the change. It's really unclear whether Trump is calling for a new mid-decade census or changes to the upcoming 2030 census. Experts state that a mid-decade census cannot be used for reapportionment, which means allocating congressional seats under the current law. Any such change to the census would likely face significant legal and constitutional hurdles, of course. And then there's also a number of, quite a bit of historic logistical challenges. Experts conclude that a new mid-decade census in a short period would be logistically impossible due to the extensive planning and resources required. The move is linked to Trump's efforts to influence redistricting in Republican-led states like Texas, which could lead to additional GOP congressional seats, although we hear Democrat Democratic governors saying, well, we're going to step up to the plate and we're going to do some things as well. And we don't want to have to do this, but we know that we are in a different game now. And so New York and California, those two states are responding as well to what Texas is trying to do there with the redistricting. So this is such an unprecedented time, guys. Things are so different now. And so with immigration, we're just trying to keep up, okay? So if you have not subscribed to this channel, subscribe so that you can keep up with us at the pace that we're going. We're trying to give you the right information at the right time so that you know how to make your decisions. All right, now with that being said, we're going to go right into your questions, and this is our Q&A segment. Okay, let's get back on the screen here. All right. Guys, again, if you have success stories, be sure to share it below. Share it in the comments so that we can share your stories during our weekly sessions together. Thank you so much. We love seeing your victories, no matter how small. Share yours with us. Thank you. All right, let's get into your questions. Let's go down here a little bit. Okay, someone is asking about having an early consultation. You can contact our office and you'll hear what our schedule is like. And if it works for you, we'd be happy to meet with you. Some of my colleagues can meet with individuals much sooner or earlier than me. Don't let me get in the way of your immigration resolution to resolve your immigration problem. Book your consultation with one of my colleagues today. Thank you, guys. Great. I'm seeing success stories. Excellent, excellent. Okay, so a friend of mine came here as a K-1 visa holder, fiance visa, and their marriage didn't work out, and the petitioner has canceled her petition. What should he do next? Does he need to go home? Okay, so the first thing that this individual should understand is that it's going to be very difficult for him to adjust his status in a situation like this down the road, even if he marries another person down the road. And it's unfortunate that it didn't work out. The K-1 fiance visa restrictions that our government has placed on that visa is certainly to prevent fraud, right? To avoid fraud in the system, and which there is a lot of fraud with respect to this K-1 process. But your friend should speak with an immigration attorney to see what his or her options are down the road. For some people, they will be able to file an I-130 petition through another spouse down the road, but then they would have to counsel their process and leave the United States to finish the process back home, okay? That's what happens typically in the K-1 fiance context when it just doesn't work out with the petitioner. Okay, thank you. Let's keep going. Freedom Now, guys. Type in Freedom Now. Brooklyn is in the house. Good to see you. Thank you, Janet, for being here. Let's go down a little bit. Okay. Okay, so I filed my form I-751 to remove conditions, and upon check-in the status of my application, a few months ago, it says being actively reviewed by USCIS, but now it's showing the case is still being processed. So, Nini, I don't pay that much attention to all of these alerts and updates. What you should be most concerned about and what you should think about is preparing yourself in the event they call you and your spouse in for an interview. And also, if you're no longer with your spouse, have you made the appropriate conversion of your case to immigration before they approve an I-751 that was jointly filed? And maybe now you're divorced from your spouse, and this type of problem happens a lot, and it will really impact citizenship down the road. So 48 months extension is what they're given. Be patient during this time. Some people are being approved at the 2-year mark. We've seen that. Others go all the way until the very end. I have a video coming out about the removal of conditions process and some mistakes people need to avoid, including the scenario that I just discussed with you. Stay plugged in on Instagram, TikTok, and Facebook for that reel. We're going to publish it maybe tomorrow or Wednesday. It's in the queue. Okay. Thank you. Let's see. The bond is for 2 countries in Africa only at this time. At this time, the visa bond, the pilot, it's a 12-month pilot, only has Malawi and Zambia in the program. The government's rationale is that they're targeting countries that have historically high visa overstay rates, which it's interesting that European countries, folks are not overstaying from European countries or Latin American countries, or this is totally racially motivated, obviously, but they could add additional countries at any time to this pilot program. Okay. If they add additional countries, I will be sure to keep you guys in the loop on that. All right, let's keep going. Type in freedom now. Freedom now. I have a green card interview coming up. I have 2 addresses and I do go back and forth. Would that be an issue if I don't change the address and keep only one? So you have 2 addresses. My first question certainly is, what type of case, green card case is this? Is this a marriage green card case? And if so, yes, this address issue will be a problem. Okay. If the government knows about your second address, you can speak one-on-one with us for us to go deeper into understanding why you have a second address. Some people have a second address because they they want to be able to commute easily from home to work. And so that's usually the reason why there's a second address, but we'll need to go into the case that you've already filed with immigration, see and look to determine whether there are strong bona fides that were included in your filing, and help you to understand how immigration is going to analyze your facts there. Okay. But so the address issue is most critical for a marriage case. Most other types of cases, it's not really that big of a deal. Okay. Thank you, guys. Let's go down. Okay. Christopher says, I filed an I-130 for my wife. It's been more than 2 years now and it's still processing. Can she apply for a tourist visa while there's an I-130 processing? We haven't seen each other in 3 years. Wow, very long time for you guys to be separated, right? So it's most embassies will look in the system and see that there's an I-130 in process and conclude that your wife has an intention to come here permanently. She has immigrant intentions. And some embassies will just not approve the visitor visa, but it's possible that she might be approved. I've seen some embassies approve individuals in that circumstance. The biggest issue there is to ensure that whatever visa application your wife will fill out, that DS-160 application, that it's consistent with information that has already been shared with immigration during the I-130 process, because the last thing you want is for there to be some mistake and the U.S. Embassy conclude that maybe she was trying to commit fraud or misrepresentation, which they can draw that conclusion very easily if the circumstances are there. And then that could complicate her green card process. But certainly she can give it a try. I don't know which embassy she's trying this through. Some will allow it, others will say, no, we're not going to approve that. Okay. Is there any form of immigration reform that is possible in the country at this time? Benson, we've talked a little bit about the Dignity Act, and there's that. It's not really anything that is moving currently on Capitol Hill. The Dignity Act, then there's the registry, changing the date, moving the date, is to allow individuals who have been in the country over the last several years to have get amnesty. That's also that's not moving either. There's really no appetite at this time for immigration reform, none that I'm seeing currently. Type in freedom now, guys. Thank you so much for joining. I see we have some new folks joining today's live show. You've missed the news segment at the beginning. We'll post this so that you can go back and watch it. It's great to be with you guys. Thank you so much. Does the public charge new policy apply to naturalization? Example, using public benefits. I haven't seen any major changes with respect to public charge. So I'm not certain what you're referring to there. We'll have to look into that, but to my knowledge, nothing major has happened on that front with respect to public charge. And also, friends, with respect to naturalization, yes, they're talking about adding additional questions to the naturalization test to make it more difficult for individuals to pass that test. So those changes are being worked on currently. So let's stay tuned for more information about that. But as far as the new public charge policy, I'm not familiar. I'm not familiar with that, Lawson. And I do try to track anything involving public charge because that's an issue that the administration tried to use during Trump 1.0 to weed out a lot of people from the system, people who were applying for a visa to come to the United States and people who are going through a green card process. They use public charge to really squeeze people out of the immigration process. So I do believe that that's coming again in a very strong way, but I have not seen any new policy on that yet. Thank you. Share your success stories as I'm going through the questions here. I do see some. Thank you guys so much. Add any success you've seen or heard about recently. We'd love to share them. Okay, are the people who are being denied re-entry also are on the list with ICE? Would they be safe if they didn't travel? So RT is asking whether people who are being denied entry back into the United States also on the list with ICE. I'm not sure what you really mean by that, because if an individual tries to come to the United States and for some reason Border Patrol or Customs just turn them back, they're denied entry or re-entry into the United States. That's the end of the story, so to speak. ICE is not involved in something like that, unless, of course, an individual is detained at the border or port of entry, and then they're moved to an ICE detention center for and usually an immigration court process, removal process, and an interview to determine whether they have a credible fear of returning to their home country. So that's how ICE usually gets involved if they're detained, moved to an ICE detention center. Maybe I've missed it. You could reframe that question and I'll try my best to answer you. Rosemary is asking, what do I think about the $15,000 to come to the United States? Is that true? Yes, it is very true. If you go on the State Department's website under U.S. Visa News, you will see the entire thing there, how it's going to work, when it's starting. It's starting this month, and the two countries that it applies to. And they're very serious about this pilot program. They tried to do this right before COVID started, and they weren't able to fully implement it because COVID came in and changed everything. And so they've resurrected this one, okay? The bond process, it's going to be an interesting logistical thing to watch. All right, let's keep going with your questions. How long is the wait for citizens who are filing for a spouse in Nigeria? Atia is asking. Atia, wow, I'm not even sure how long it's taken the spouses. At one point, there was a 2-year wait to get a visa interview in Lagos. I haven't looked into that in a very long time. Can disorderly conduct prevent you from getting a green card? Mohammed is asking. No, it cannot prevent you from getting a green card. Okay, let's go down. Freedom Now from another McBean, M. McBean. Let's see. My husband's I-751 is still pending. He qualifies for citizenship. Do you think it's okay to submit his N-400 now while the I-751 is pending? So long as he is still in a good marriage with you, marital unity is key to that process being successful. It's fine for him to do so. If you guys, if he's at that 2.9-year mark of being a resident, the naturalization application historically would push the I-751 process a bit faster along. So he could go ahead and do that and get his naturalization if he meets the other requirements, certainly for naturalization. Thank you. Bobakar says that he's been following me for 5 years now. That's awesome. Thank you. Thank you for being here. What would happen if the petitioner, the I-130 petitioner, is incarcerated and you get an interview for the I-485? What should you do? We've been in this situation quite a bit of times over the years with our clients, and so it's possible for your process to kind of take a pause, so to speak, during the time that your petitioner is incarcerated. You can contact us for more assistance with that case, okay? Let's see. Let's go down a little bit. Do I know whether they're still approving TPS for Haitians? Someone who came in 2024, her application is still pending. I have not seen any or heard any news regarding anyone being approved for TPS for a country that the government has clearly announced its intention to shut down, including Haiti, okay? I have not seen any approvals along those recently along those lines. What should I do if I don't have any family or I'm not married? How can I get a green card? What should I do? So in this type of scenario, this is a case evaluation, not a consultation that you would have with our firm, because you're wondering, well, do I even have any option for a green card? So a case evaluation at our firm is $150, and you'll be meeting with a non-attorney, and we would look to find out whether you've ever been a victim of a crime here in the United States. Have you ever been married? And if so, were you abused in the marriage? Who were you married to? And look to see whether there's any humanitarian option for you for a green card, okay? So that is a case evaluation at our firm. And that's a process that you can book on your own on our website at McBeanLaw.com. Just go to our contact page and the instructions are there, and you can book a case assessment evaluation with our firm. Thank you, guys. Free. And you could even get a case evaluation done this week. Okay, there are a lot of slots available for case evaluations. So guys, if you'd like an evaluation to see if you have an immigration option, go to our website and just book a case evaluation, not a consultation. All right, Freedom Now. Let's keep going. What do I do next? My wife got her I-130 approved. What should she do next? She's in Haiti. And Haiti has a ban on it. So friends, the question is, are you a U.S. citizen? Are you a U.S. citizen? Because if you are a U.S. citizen, then it's possible for your wife to be able to come in through you, despite the fact that that Haiti is on the travel ban list, which is really awful. So as an immediate relative of a U.S. citizen, she can get in. However, the biggest challenge is, where in the world will she be interviewed? Is she going to be interviewed in Montreal? Is she going to be interviewed in Barbados? Is she going to be interviewed somewhere in South America? Okay, that's what's needed next. She'll need to be in another country, and the visa application process will need to be processed there in order for her to be interviewed for the green card. So because the embassy in Haiti has been closed for a very long time. Okay, so she could reach out and see whether she can get some help from our firm. We'd be happy to see what we can do for her. Okay, and you, of course. Thank you, guys. Thank you. Thank you, guys. Let's see. Let's go down. Let's see. Let's go down a little bit. How long after you've received your marriage green card can you start filing for your parents? Well, once you become a U.S. citizen, you could file for your parents right away. It requires U.S. citizenship, right? U.S. citizenship is what will happen. Okay, here's a super chat. A question. My question is that my grandson was petitioned for by her mom. Okay, it was approved. It will come next month. Does he need to wait for his green card before he can come back home? Zami, come back home. That's the part that's throwing me off here. Is the child here in the United States? If the child is here in the United States, then the child, did the child overstay a visa? Because if the child had overstayed a visa and the parent is not a U.S. citizen, the child will have to go back to the embassy to finish the process. But if the mother is a U.S. citizen, the petitioner, then the child can adjust his or her status here, his status here. Okay, I'm not sure what you mean by wait before he come back home. All right, let's keep going. Let me jump back over here. Thank you, guys. I'm filing the I-751 waiver. Can I skip the address of my ex-spouse because we're not together anymore? So I can't tell you, Kurt, what to put on that application. Privately and publicly, I can't tell you what to put on something like that without committing malpractice, okay? But I will caution you here with regard to the I-751 waiver process. The government allows you to do it under just some limited circumstances. So make sure that you meet one of these circumstances. Number one, you were in a genuine marriage, but it ended due to divorce. Number two, you were in a genuine marriage, but it ended due to abuse or extreme distress and all of that you were facing in your marriage. Number three, you suffered extreme hardship during that 2 years you guys were together, or you had that green card, I should say. And so you've got to just focus in on meeting the burden under one of those prongs, so to speak, and make sure that your waiver is done right. Okay, because if it's not done right and you go out of status, the government will place you in removal proceedings. Okay, let's see. Let's go down a little bit. Can you get a green card if you're under TPS? James is asking. Yes, James, you can. If you're eligible for a green card, you're eligible for a green card. It just depends on how you're going to get to that point, who the petitioner is, and your history. How did you come to the United States? How did you enter, and some other factors. But yes, it's possible to get a green card if you have TPS. Can a parent file for his or her child if that child is over the age of 21? Yes, a green card holder parent can do so, as well as a U.S. citizen parent can do that. The only limitation here is that if you're a green card holder, you cannot file for a married child, okay, or son or daughter. You cannot file for a married child, but aside from that, you can certainly file for them if they're over 21. Let's go down a little bit. What can one do to get deportation defense even when they have not started any process with USCIS? So you don't have a second a way forward at USCIS and you're just in immigration court. Well, we would have to look at your background and see if you're eligible for relief through the judge. Are you eligible for cancellation of removal, which is available for individuals who have been here for 10 years or longer and before going into immigration court, and you have a spouse, parent, or a child who is a U.S. citizen or a green card holder who have some significant problems and they would suffer in a major way if you're deported, we would be looking at things like that. Is asylum appropriate for you, right? How long have you been here? Where are you from? What's going on in your country? Those are the types of questions that we would be asking to see whether you're eligible for relief through the immigration court process. Okay, let's keep going for just a little bit more before we transition. Let's see. Great question, though, about deportation defense. My I-130 was approved. Then we applied for the I-485 adjustment of status shortly thereafter, but I was already out of status. Do I have a reason to worry? Calvin is asking. So Calvin, who filed the I-130 on your behalf? Are you in removal proceeding? These are the questions that are really important with respect to determining whether you have anything to be concerned about or not with filing the I-485. Are you eligible for the I-485 process adjustment of status? Because if you're an immediate relative of a U.S. citizen and you enter the country the right way, or you have a way of showing land-in papers, then you might be eligible to adjust your status. The other question is, what type of record do you have? Do you have a criminal record? And if so, what's on that record, right? Those are the factors that will go into determining whether you have anything to be concerned about or not with respect to the I-485. Where are we located? So we're located in White Plains, New York, okay, Westchester County, but we work with clients everywhere across the United States. Thank you, guys. What's the chance of getting an I-601 approved after visa overstay, marriage based in Jamaica? You know, Nicole, it just depends on your background, and it depends also on not your background, but it depends on the extreme hardship that would be connected to your U.S. citizen or green card holder spouse or parent, because the I-601 waiver is going to require a showing of extreme hardship. We had a terrific testimony that we shared last night to our subscribers about a Jamaican client of ours who had gotten an I-601 approval based on fraud and misrepresentation, and it's an I-130, I-45, and an I-601 approval all happened at the same time. All right, so go check out that success story. I don't believe it's on our website quite yet, but if you're a subscriber, check out your email. It should be in your inbox. So it just really depends on the case and whether extreme hardship can be proven. All right. Thank you. Let's go down a little bit. Let's see. I, as the beneficiary, has better economics. Is it still required for an affidavit? Okay, so this person, I think, is asking whether an affidavit of support is still required, despite the fact that he or she has the financial means to take care of him or herself. The affidavit of support is required by the petitioner. Okay, it is still required by the U.S. citizen or green card holder petitioner. I came here legally over 5 years ago, and I've overstayed my visa. My children, my child is filing for me soon. Is there any problem now? Is everything changing? Georgia is asking. So Georgia, you should be fine with adjustment of status through your adult U.S. citizen child. You will need to prove how you came to the United States. Yes, there are changes that USCIS is had announced last week, and I've talked about it as well in my short reels and videos. You could also check out a shorts that I published to you guys yesterday on YouTube, and in which I talked about the fact that one of the biggest issues that USCIS shared last week is that they're going to cut back on the request for evidence and the notice of intent to deny the case for individuals who make mistakes on their applications, or they did not include all of the evidence that's required. USCIS is saying we're not spending as much time on that whole RFE thing and NOID thing. We're just gonna go straight for a denial. And oh, by the way, we might also place you in removal. Right. We might also issue a notice to appear in immigration court because we know that you're here undocumented. We're going to beef up more of that. That's really what they did, what they're saying. OK, so you want to make sure that your case is prepared properly. But if you're doing it on your own, fine. Just read the instructions, all of it, and don't miss anything, and make sure you do it right. Because like I said yesterday, it's one bite at the apple, although you could still try again. So that's the biggest issue. I wish you well on your case, okay? Let's see. My father is here on a tourist visa, and can we apply for adjustment of status again, even if he had surrendered his green card before? Yes, he could still go through the process a second time to become a resident. Let's go down. Would it be safe for one to file an I-130 via a spouse if the beneficiary has a final removal order? If you had thought log is asking. So yes, we're still doing it. Yes. Yes. Yes, you have a final removal order. do you have a process through that spouse or whoever that individual is who's filing for you? If you have a way to adjust your status through that individual, I would say absolutely go ahead and move ahead with that process. Okay. But certainly get some legal help with it because there are some risks inherent in what I'm sharing with you here publicly. So just work with an attorney on this process. Yes, the new CSPA process. I'll touch on that in a video later this week. There has been a really not so great update with regard to the Child Status Protection Act that's going to impact mainly people who are part of a EB2 and EB3 process, but I'll talk more about that in another video. How long does it take for unmarried children over the age of 21 to get a green card? How long it takes for unmarried over 21 for a green card holder to get a green card. So the petitioner, is the petitioner parent a green card? It's going to take several years. I would say even up to 10 years, depending on where the individual is located. If they're located here in the US, it's going to take up to 10 years because they're going to need a waiver. If they're outside of the US and waiting for the process, you're talking maybe about 7 years or so for it to happen. All right. Thank you guys. Great questions today. Freedom now. Okay. Go down a little bit. Let's see. Okay. Question is, can a green card holder file a family-based petition for a sibling? No, green card holders can only file for a parent or a child who is unmarried, and that's it. Once the person becomes a U.S. citizen, of course, he or she can then file for a sibling. Okay, thank you guys. Thank you. Let's keep going. Let's see. I thought I saw, where is that? Assuming that your clients live in Alaska, how do we accompany them to interview for their adjustment of status? We would have a local attorney appear at that interview with you, okay? We used to do the telephonic appearances. Most USCIS field offices aren't allowing that anymore. So it would have to be through local counsel, through our network, nationwide network. It's good to have a strong network. If there's anything I know how to do is network. All right, guys. With that being said, I'm going to transition into what I find to be a very interesting story about a couple who voted for Donald Trump. And then this happened.
All of my life, 50 years I've been here, I've never been harassed by Border Patrol on this side of the border like this. This is outrageous.
Why are we not allowed to be here? Because we're not white? Our skin doesn't match?
That's George Doylis. He and his wife are from Imperial Valley, and they love to camp. So when they were headed up to a dental specialist in North County on Wednesday, they decided to explore Jacumba and this area around Boulevard. They headed up this road to see if they could find a campsite, and that's when they say their day took a very different turn.
We didn't think anything of it. We're American citizens. We're on U.S. soil. Why should we be afraid?
George and his wife Esmeralda say an unmarked SUV started following them and pulled them over. They say Border Patrol agents first approached wearing masks.
So the reason why we're stopping you is because you did U-turns and there's a known alien out in the area.
He told the agents where they were going and that they did not consent to any search.
If you have a dentist appointment, it probably wasn't the best decision to be out in the middle of nowhere.
No, we have the right to travel anywhere we want to travel.
You do. You're absolutely right, you do. And I actually have the right and authority to stop you.
The couple sat in their car as the agents brought a canine.
It's called reasonable suspicion.
Do you think that they had reasonable suspicion to stop you and search your vehicle?
Not at all. Not at all.
The dog did smell a small amount of legally purchased cannabis, so they got out for a full search. 30 minutes in, the agent says he could take their vehicle, but
I'm going to go ahead and let you off with a warning.
George and Esmeralda both voted for the first time in 2020 and again in 2024 for President Donald Trump. As they see his immigration crackdown, do you regret your vote?
Yes, I do. Very much so. I feel shame, guilt, and anger at the same time.
How awkward would it have been to say that he does not regret his vote? Okay, of course, we're all entitled to vote for whoever we want. This is America after all, right? But here you have Hispanic husband and wife team they just want to go camping and smoke a little weed or eat it or whatever they want to do with it and just have a good time out there. And they just happen to be Hispanic and they happen to have a little accent. Yes, they're US citizens, but that doesn't matter, right? In this circumstance. And now he regrets voting for Donald Trump. Elections have consequences, guys. And just keep in mind that there really probably was no reasonable suspicion to stop them. Absolutely. This was probably an unconstitutional stop right here. However, when the dog detected the marijuana, of course, that opened up the ability of law enforcement to go a little deeper into the car and see what's going on. But this story, guys, reminds me of the fact that not really remind me, but shows that this racial profiling is happening. It's real. It doesn't matter what the administration says. Oh, no, we're not doing that. We're not doing that. That's exactly what they're doing, which is why the Supreme Court's review of this issue of what is happening in Los Angeles is so very, very important. Now, let's go into some of your success stories, guys. Excited to share these stories with you. All right. So Kathy says, I got my green card at the beginning of July, before July 4th, actually, and we filed for adjustment of status and a marriage I-130. We're in a bona fide marriage. Congratulations, Kathy. Great job. Sarah says, recently got my green card after waiting for 20 months. Thanks be to God. Congratulations. That's wonderful. Let's see who else is here. Cox Fame says, being here for 30 years, married in 2004 to a U.S. born citizen. We started the process in 2010, but a crooked lawyer scammed us with thousands of dollars. We restarted again in 2017. My I-6018 is approved. Now waiting for the consular interview. Wish me luck. I'm glad that you finally got to this point, but my goodness, that's a long journey. RJ974 says, I got this after 180 days of applying for asylum. Approval of my case has been rendered. We approved your I-765 application on June 18th. Great. It's good to get that work permit. Okay. It's really good to get that work permit. That's awesome. Congratulations again. And the success stories that you guys have shared today, we're going to put those stories on the screen. If you haven't figured out how we're doing this, we're going to put those success stories on the screen next week. Guys, we're here for you at McBean Law, 914-898-9488, located in White Plains, New York, working virtually with clients nationwide. And follow me on Instagram and TikTok and other social media platforms, Facebook. We're also on Threads as well. So if you like Threads, you'll find me there as well. And, I can't leave here today without a little bit of a laugh, right? Check this out, friends.
If me born on Independence Day, that mean me not fi go school. Me independent now. If me a born Jamaican, that mean me get free party every week. Who name Bob Marley? You know my cousin? Mommy, I choose some can wine before me walk.
Oh, that's awesome. Love it, love it, love it. Guys, it was so nice being with you today. Thank you so much for being with me, and I will see you in the next one. Have a great rest of your day. Bye bye.